right, next cases the court's going to call will be State of North Dakota versus Michael Scott Jakey, CR 36, CR 16, and 26, CR 50. Present in court, Attorney Mary Depute for the state.
I'm here by special appearance to executive.
Please have a seat. Please have a seat. Mr. Jacobson is personally present and without counsel. Sir, good morning. Were you present in court when your rights were read to you earlier?
Sir, I don't consent to this hearing because of lack of jurisdiction of the court over me. I'm not a 14th Amendment citizen anymore.
And here we go. The hearing starts with one of the most common sovereign citizen claims. I'm not a 14th Amendment citizen. In their world, simply declaring yourself outside the legal system somehow makes the charges disappear. But courts hear this all the time, and it never works.
It's in my documentation that no one ever reads.
Sir, I asked you a question.
I told you.
So,
I am not.
Sir,
I'm not.
Sir,
under your
stop talking over me. I'm going to ask you a question and you're going to answer the question.
I don't understand.
So I'm asking you, were you here when the rights video was played not once but twice this morning?
I was here.
Do you understand the rights as they were read to you?
I don't stand under anybody.
I'm asking if you understand the rights that were played for you.
I don't understand.
Okay, so let's talk about what you do and don't understand, sir. Do you understand the English language?
I do not have jurisdiction over me. If you look at the documentation.
Answer my question, sir. Do you understand the English language?
I don't understand.
Okay, so I'm asking you if you understand the English language.
I don't stand under anybody.
Sir, I'm asking you if you understand English. I asked the question in English. You responded in English. I think you understand.
Your answer.
But I'm making a record, sir, to make sure that we're clear.
This is what makes these hearings so surreal. The judge asks a basic yes or no question, and instead of answering, the defendant launches into a speech about land, water, and contracts. The irony is almost unbelievable. He insists the court has no jurisdiction while standing in that very courtroom responding in perfect English.
In court many times, and I've heard those rights.
And so you understand those rights.
Don't stand under anybody.
That wasn't the question. Do you understand?
That's what you're asking me to do. I don't stand under you.
Sir, you've already said you made a special appearance. So I'm asking you if you understand. Do you understand?
I comprehend them.
Okay, comprehension is good enough. You comprehend them. All right. Do you comprehend that you have the right to an attorney? Do you comprehend that you have the right to either an appointed attorney if you financially qualify for one, the right to hire an attorney of your choosing, or the right to represent yourself if you can do so knowingly, voluntarily, and intelligently?
I don't consent to this hearing because I'm not under your jurisdiction.
Sir?
I'm under the jurisdiction of the land.
I
Not in the
understand.
jurisdiction of,
Sir?
of your contract law.
Okay. Do you comprehend your rights to an attorney?
I don't need it.
After all the word games, he finally admits he comprehends his rights. That one word basically destroys the entire performance. No matter how much legal-sounding jargon someone uses, the court only cares whether they understand what's happening.
Attorney.
Has anyone threatened you, forced
No one has
you?
threatened me.
So let me finish before you start talking. Sir,
I've been here the last 7 times.
stop.
Nothing has happened. Read the file.
Sir, stop interrupting. Stop trying to talk over me. I'm asking you a question. Has anyone threatened you, forced you, or coerced you, or in any way made any promises to you in order to get you to waive your right to an attorney?
No one has.
Thank you. So we are here today for a number of dispositional conferences. A dispositional conference is a conference set to determine how you intend to proceed.
Your Honor, if I can interject, I'm sorry, but I think there's a little more complexity to this procedural posture. In case 16, the defendant had filed a motion to dismiss. The motion to dismiss, a response was filed with the state on June 28th. At the last status conference, the defendant wished to raise the same motion in all 3 of his cases. At that time, it had not been served. Although the motion still has not been served, it has been filed in the 2 remaining cases. And so I believe that there is a pending motion before the court in all 3 cases.
So
the judge deserves a lot of credit here. She never raises her voice, never gets rattled, and never lets the courtroom turn into chaos. That calm approach is often the most effective way to deal with someone trying to derail the process.
Wasn't noticed as a motion hearing. Rule 3.2 requires that the moving party file a notice of motion declaring whether or not the motion is to be heard for oral argument, to be heard for an evidentiary hearing, or to be considered under briefs. That notice of motion wasn't filed, requesting a hearing. So today, it's not properly before the court, even if it was properly served.
I brought it to the clerk's
Sir-
report. I could not get a hold of Ms. Pugh. She would not
So,
return my
stop.
calls.
This is where I'm talking. So those motions have not been served. So technically, even if the state's filed a response, they're not ripe for the court's consideration. So the court is not going to take up motions. Furthermore, these are Judge Naram's cases. I'm not going to rule on motions in Judge Naram's case or cases that are not properly before the court and noticed for hearing. As far as the court's concerned, all that's before it today properly is a dispositional conference. Sir, you have 5 options at a dispositional conference. You can schedule it for a jury trial. You can request a bench trial. And if the prosecutor agrees and the court agrees, the court can schedule it as a bench trial. You can request a continuance. You can change your pleas from not guilty to guilty today. Or you, lastly, can choose to schedule a change of plea for a later date.
Well, let's do a continuance until Judge Naram gets the case so he can make a decision on it.
All right, so what I told you before is right now those issues aren't properly before the court because they haven't been served properly following the
We'll
rules.
serve them properly and we'll just do a continuance then.
All right, Ms. Depute, your thoughts?
That seems appropriate to me. I believe that maybe there are not notes in the docket. I believe it was contemplated by the previous judge that this would be a motion hearing. It was discussed at that time. The state is ready to proceed. But if Your Honor doesn't wish to hear it today, then I believe we continue it until Judge Naram can hear the motion.
So Judge Naram's next court date in McIntosh County is 6 weeks away.
That's fine. We can't get nothing done if there's another judge here. Gotta have Judge Naram.
Well, he's assigned to these cases, and typically once a judge has been assigned, unless there's an agreement or stipulation between the parties, I'm not going to sign a motion or consider a motion that wasn't on the docket as a motion hearing. So I will continue this matter, all 3 matters, for a dispositional conference and a motion hearing for November 13, 2023. It'll be set at 9:30 a.m., but I'm sure Judge Naram will call that case last. Just so you're aware of that. Mr. Jacobson, it probably will be late morning before that motion is heard. Ultimately, Judge Naram will be able to decide the motions, assuming that they are properly before the court at that time. And so that means proper service, proper notice of motion. You'll need to file a 3.2 notice of motion that declares whether it's for evidentiary hearing purposes, oral argument hearing purposes, or both. And at that time,
Even though the defendant keeps claiming the system is corrupt, the judge still explains exactly what he needs to do to get his motion heard properly. That's the part many people miss. Courts follow procedures. If you don't follow the rules, your arguments won't be considered.